Good morning, and thank you for joining our webinar hosted by the NVTC HR and Benefits Committee. We are happy to have Jennifer Plasinski from Venable as our speaker today. We are also recording the webinar and ask that and we'll address all questions at the conclusion of her presentation. At this point, I'll turn it over to Jennifer.
Hi, everyone. Good morning. Thank you for attending. Today we're going to talk about mandatory paid sick leave and the effect on federal contractors. As you're probably aware, President Obama signed an executive order back in September of 2015 and it established paid sick leave for federal contractors. The Department of Labor was charged with issuing regulations. Their notice of proposed rulemaking came out in February of this year. There was a comment period which closed back in April, and the Department of Labor received over 35,000 comments. The final rule, which is what I'm going to be referring to, the regulations that are implemented, was published on September 30th of this year. And as far as the timing, this final rule is going to become effective on contracts, on certain contracts, beginning January 1st of 2017. So I just want to briefly go over what I'm going to touch on today. We want to talk a little bit about how the executive order and the final rule are going to apply to your organization and whether it's going to apply to your employees at all. We're going to talk about how the paid sick leave accrues, because that's going to be very important. There's a lot of obligations if the final rule does apply to your organization. We're also going to talk about the reasons that the employees can use this accrued paid sick leave. It's much broader than, the reasons are much broader than what we traditionally think of uses for paid sick leave. We're also going to talk about the interaction between these regulations and existing paid sick leave laws. Some of you might have employees whose primary work location is in Washington, D.C., which has its own paid sick leave law. Others might have employees in Montgomery County, which has its own paid sick leave law. So we're going to talk about how those interact with regard to these new regulations. Also, I want to talk to you a little bit about what your obligations are going to be if the final rule does apply to the contract and the employee. We're going to talk about how to respond to the request for leave, as well as your record-keeping obligations under the final rule. Finally, I'm going to touch briefly on the new overtime regulations, which are scheduled to become effective December 1st. Of this year. I'm going to touch briefly on that, but the primary focus of the presentation is going to be the mandatory paid sick leave. So in order for the regulations to apply to you, you need to look at two things. You're going to need to look at what contract is covered, whether the contract is covered by the rule, as well as whether the individual employee is covered by the regulation. So with respect to the timing, I had mentioned earlier that the final rule is going to be affecting contracts beginning January 1st of 2017. So as you can see, it's going to apply to contracts with the federal government that result from solicitations that are issued on or after January 1st of 2017, as well as those that are awarded outside the solicitation process on or after January 1st, 2017. You need to also be aware that if you have contracts that were entered into prior to January 1st of 2017, it's also going to be covered by these new regulations if the contract is renewed, if the contract is extended, or if the contract is amended pursuant to a modification that's outside the scope of the contract. And with regard to that extension, it's not going, the new regulations are not going to apply unless the extension is made pursuant to a term in the contract as of December 31st, 2016 that provides for a short-term limited extension. You should also know that contracts that result from a unilateral exercise of a pre-negotiated option to renew an existing contract by the federal government is not going to be covered by the new regulations. So that's the timing of the contract coverage. You also need to look at the type of contract to determine whether these regulations are going to apply. So the final rule in the executive order basically is going to apply to the same contractors that are covered by the regulations that implemented the executive order that establishes a minimum wage. So if you're covered by those regulations, this is also going to this paid sick leave regulation is probably also going to apply to you as well. So more specifically, the types of contracts that are covered by the rule are procurement contracts for construction that are covered by the Davis-Bacon Act. Also those service contracts that are covered by the Service Contract Act. Concession contracts, including concession contracts that are excluded from the Service Contract Act. As well as contracts in connection with federal property or lands and related to offering services for federal employees, their dependents, or the general public. Also, you should keep in mind that the rule applies to federal subcontracts that fall under any of these types regardless of the value of the contract. So unlike some of the other regulations, there is no contract value associated with the coverage. So that's the first element that you need to establish. Do the regulations apply to the contract itself? The contracts do not apply, the regulations do not apply to specific contracts that include grants, procurement contracts that aren't subject to Davis-Bacon, services, contracts for services that are exempt from coverage of the Service Contract Act, as well as contracts for the manufacturing or furnishing of materials or supplies to the federal government. So those are all excluded from the coverage. So now we're going to switch over to employee coverage. And this is really a lot broader than what we've seen in the past. So we've got to have, so with respect to employee coverage, you have to hit two elements. So you have to, the employee has to be performing work, quote, on or in connection with covered contracts, and I'm going to get back to that in a minute, as well as employees whose wages who are governed by the Davis-Bacon Service Contract Act or the Fair Labor Standards Act. So with regard to that phrase, on or in connection with, I want to explain a little more detail what that actually means. So an employee performs work, quote, on a contract if the employee is directly performing specific services that are called for by the contract. That's pretty understandable. With regard to the in connection element, so an employee is going to be working on a covered contract in connection with it if he or she is performing duties that are necessary to the performance of the contract but isn't directly engaged in performing the specific work that's called by the contract. So that's fairly broad there, and the regulations do provide some guidance on what that, quote, in connection with means. They provide two examples. One example is a security guard who is patrolling or monitoring a construction work site where Davis-Bacon Act work is being performed. The second is a clerk who is processing payroll for Service Contract Act. So again, very, very broad here with regard to that in connection with covered contracts element. You should know that there is an exclusion for those employees who work in connection with a covered contract. So if an employee is spending less than 20% of their work hours in a work week performing work in connection with covered contracts, the final rule is not going to apply. However, if you're going to use this exclusion, you're going to need to keep an accurate record as to which work that the employee is performing is covered and which is not covered. And again, this 20% exclusion rule is applicable only to those employees who are performing work in connection with. You cannot use this exclusion if the employee is actually performing work on a contract. And for those of you, if any of you have collective bargaining agreements, if you have a collective bargaining agreement in place that already provides for 56 hours of paid sick leave, the regulations will not apply either. So I wanted to talk about a little bit about the accrual and carryover. So as I've stated, the general gist of this is an employee is going to get 56 hours of paid sick leave on an annual basis. So what you can do is you have two types of accrual options as far as how to figure this out. So the first one is you can provide sick leave. It's going to accrue at a rate of 1 hour for every 30 hours worked, quote, again, on or in connection with a covered contract up to 56 hours per year. I'm sorry, up to 56 hours per year, yes. So in this case, if you're going to actually track and accrue the sick leave in accordance with this per 30 hours worked, if you use this option and you track this, you can limit an employee's accrual to having no more than 56 hours at a time. So basically what that means is once the employee gets to, if you're doing the accrual option, once that employee gets to 56 hours, even if they work another 30 hours and they would accrue 57 hours, you can actually say, no, you already have your 56 hours, and we're not going to let you accrue anymore. And that would carry over from year to year. That might be the most economical option for some of you. The other option is the front-loading option. This is definitely probably less burdensome to some contractors, but it actually results in the employee having more paid sick leave, potentially more paid sick leave. So what the front-loading option does is you can just go ahead and say at the beginning of the accrual year, okay, employee, you're a full-time employee, and I'm going to go ahead and give you your 56 hours. I'm not going to track your work. I'm just going to give you your 56 hours. But know that if you do that, you need to allow at the end of the accrual year any accrued unused leave to carry over into the following year. So let's say, for example, January 1, 2017, you say, okay, employee, I'm going to give you 56 hours of paid sick leave. I'm not going to do the accrual option. At the end of the year of 2017, that employee hasn't used any of that sick leave, so their sick leave balance still is 56, right? You have to carry that 56 hours over to the following year, and because you're using that front load option, they're going to get another 56 hours in 2018, at the beginning of 2018, so they will be allowed to accrue at that point 112 hours of paid sick leave. So where one has, benefits from the administrative aspect, the other one has, the other one is maybe more economical or more financially efficient for your organization. So you really have to work through which is the best option for you. I did talk about that accrual year. It's fine for you to choose what the accrual year is. You just have to do it on a consistent basis. If it's the day the employee starts working on the contract, you can use a calendar year. You can use your fiscal year. You just have to do it consistently. And know when we're talking about employees that are covered, when we're talking about those hours worked, the Fair Labor Standards Act definition of hours worked applies. So when you're using that accrual option, 1 hour for every 30 hours worked, the Fair Labor Standards Act definition is going to apply there. This is in contrast to what was in the proposed rulemaking, which included all paid time off. So here this is truly, if an employee is working for you, that is the basis for the accrual for the paid sick leave. Now, I know you're sitting here thinking, okay, well, the Fair Labor Standards Act and these other statutes don't require me to keep records for the hours worked for my exempt employees, from those employees who are exempt from the Fair Labor Standards Act. And that's true, right? And you can continue to choose not to do so. All you need to do in that case is, for those exempt employees who are full-time, you're just going to assume that they're working the amount of hours that their regularly scheduled hours are for. So if you have a 40-hour work week, that's what the accrual is going to be based on. If you have a 37.5, that would be what the accrual would be based on. If you got those part-time exempt employees, then you just do a pro rata share of what their regularly scheduled hours are worked, and you do not have to keep those formal timekeeping records. You should know also, as far as the increments, you don't have to allow the employees to accrue leave in smaller than increments of 1 hour, but you do have to count those increments toward the next hour of accrual. So the point is, you can go ahead and track the leave in according to 1 hour increments as far as the use and thereof, but you do have to do those those decimals, right? It's anything less than an hour, because that's going to have to carry over to the next hour of accrual worked. Okay, so you're telling me, okay, we've got my employees are going to accrue this, and what's going to happen when they separate? So the good news from the financial aspect is upon separation, for any reason, you don't have to pay out the sick leave. But you should know that there is a right to the reinstatement of the leave. And what that means is, if the employee separates from your organization, and let's say they have accrued unused paid sick leave of 20 hours, if you rehire them within the next 12 months, they are going to start with a balance of that 20 hours. It doesn't go away. But if you rehire them after the 12-month period, they don't have that right to reinstatement. This is actually good news, quite frankly, because under the notice of proposed rulemaking, the contractor was actually required to reinstate leave not only if you yourself rehired that employee, but the successor contractor was also required to reinstate leave, and that just would have been such an administrative burden on behalf of the successor contractor. So this is actually a more positive result than what was proposed in the notice of proposed rulemaking. Do know, though, if depending on your policy, you can certainly choose to pay any accrued unused sick leave at the time of termination. So if you do pay that out, then the employee, of course, is not going to have that right to reinstatement. So again, for my example, if you have that employee who has that 20 hours, they're separating, they're resigning, you pay them out for the 20 hours, and you rehire them, in 6 months, they're going to start with a leave balance, a paid sick leave balance of 0. Okay, so the reasons why an employee can use the paid sick leave if they're covered, these reasons are much, much broader than, again, what we've seen in the past, although I will say that these regulations track the trend of the paid sick leave laws that we are seeing from states and counties and cities. It really provides the employee with really, really broad reasons to use this paid sick leave. So the first reason is a physical or mental illness, injury, or medical condition. And know that this is broader than the Family Medical Leave Act's definition of serious health condition. Much, much broader, because it's defined as any disease or sickness or disorder or impairment or trauma to the mind or body. What's really important is treatment by a healthcare provider is not required. And examples include a common cold, an ear infection, upset stomach, etc. So really broad as far as the physical sickness or illness. The paid sick leave also may be used to obtain diagnosis, care, or preventative care from a healthcare provider. Also, they may use it for any individual related by blood or affinity whose close association with the employee is the equivalent of a family relationship, who has any of the two reasons I just described. And with regard to that close affinity language, the employee just has to say that they have a significant personal bond with this individual. They don't have to provide any certification for it. And in fact, the rule states you're not allowed to intrude upon the employee's personal life into inquiring why there is this, quote, close affinity with this individual. And all the employee needs to do is say, this person who I'm going to care for and use my paid sick leave for is like family. That's all they have to say to be able to use the paid sick leave. And the final reason is domestic violence, sexual or assault, or stalking. And this is probably the area that we don't think traditionally of using paid sick leave for, but this is the trend that most states and cities with paid sick leave laws are incorporating, this idea of using it for domestic violence or assault or stalking. And know that when we're talking about this particular reason, we're talking about if the employee is going to get counseling, any related legal actions, and also it can be if the employee is using the leave to help an individual described in 3, anybody that they have whose family or they have that family relationship with, they can also use this paid sick leave. Okay, so told you when you're covered, when your employees are covered, how it accrues, and the reasons why employees can use it. So now we're going to talk about, okay, so I've got this employee, they're covered, they've accrued paid sick leave. How do I go about responding to it? So employees are permitted under the regulations to request the leave orally or in writing, and they can do it in person, they can do it by telephone or email. So pretty much any method of communication. The burden on contractors is a little more stringent when it comes to the response. The contractors can require that requests for leave have to be at least 7 calendar days in advance if the need for leave is foreseeable, right? But from a practical matter, when you're ill, it's not always going to be foreseeable. So in that case, the employee can provide as much notice as practicable given the circumstances. No, this is a little different than the Family Medical Leave Act. The only time that the contractor is permitted to require certification of the absence is in cases of leave related to domestic violence, sexual assault, or stalking. And in that instance, the employee is permitted to what they call self-certify. So basically telling you this is what I'm going to do. But if there is an absence from work for 3 or more consecutive full days, you are permitted as a contractor to ask for a doctor's note from the healthcare provider. However, please understand that if you're going to require this certification, in the case of being out for 3 or more days, you need to let the employee know beforehand that you're going to require such notice. So I would recommend just putting in your handbook, contractor retains the right to request medical certification in the event you are absent from work for 3 or more full consecutive days. And again, this is different than the Family Medical Leave Act. For those of you who are subject to that statute, you cannot seek a second medical opinion, and you can only ask the healthcare provider to clarify the contents of the certification, meaning if you're provided with that medical note, in the case of an absence of 3 or more days, you can go ahead and say, wait, this doesn't make sense, and you can have that healthcare provider clarify that certification. The employee's request has to include an estimate amount of leave time, but know that you can't bind the employee to that estimated leave. You have to be flexible. And as the contractor, you are required to respond to a request, quote, as soon as practicable. And the regulations state that that is likely to be immediately or within a few hours. Now, do know that if you're going to deny a request for leave, this is only for denials, you need to deny in writing, and you need to explain why. And if you're saying we don't have enough information to grant or deny your request, know that you have to give the employee 5 days to submit a corrected documentation. Okay, so we also talked about, or I also mentioned, we're going to talk about the relationship with other laws. And as I indicated, there are several states and counties as well as cities that have their own paid sick leave laws. So with regard to any other paid sick leave laws or any other laws that provide leave entitlement, know that what is in the regulations, if they apply to your contracts and your employees, it's going to be the minimum standard. So it's okay if you're required to give more than what these regulations require. You're just not permitted to provide less to your employees. So if you've got collective bargaining agreements that are in place and other laws that give greater rights, you not only have to comply with these regulations, but you have to continue to comply with those leave laws and those paid sick leave laws that give greater rights. And if for those of you that are covered by the Family Medical Leave Act, know that you still have to comply with those requirements. However, under federal law, you're permitted to allow that the paid sick leave that it's accrued under these regulations to run concurrently with the unpaid leave to which an employee is entitled to under the Family Medical Leave Act. Also, even if you have existing laws that apply to you with regard to the amount of paid sick leave to which an employee may be entitled, you still have to comply with all the obligations under these regulations, meaning all the record-keeping obligations. You have to still comply with the requirements with regard to responding to leave requests. So like I said earlier, what comes to mind are the, D.C., you may have employees in D.C. as well as Montgomery County, and Montgomery County actually just amended their paid sick leave. In the intersection, quite frankly, of both these regulations and Montgomery County is pretty complex. So I really advise if you have employees in Montgomery County, then that's their primary work location, you've got a work site there, really take a deep dive into comparing those two, the regulations as well as those entitlements under Montgomery County law, because it's very complex. All right, moving on. Okay, so as far as existing PTO policies, paid time off policies, so I know a lot of you are sitting there saying, okay, well, I've got a PTO policy in place. What's going to happen to that? I have a paid sick leave law in place. What's going to happen to that? So again, as long as your policies are at least as generous as these regulations, you're going to be fine. So what that comes down to, in essence, is if you've got a policy that provides for 56 hours of PTO and you can use that PTO for any purpose, then you don't have to provide separate paid sick leave, even if the employee uses the PTO for purposes that aren't covered by the rule. So as long as you provide 56 hours of PTO, you're okay. However, if you provide more than 56 hours of paid leave, you have two options if that's what your existing policy does. You can go ahead and say in the policy, all your PTO that you've accrued under this policy may be used for any purpose that is enumerated under the regulations, and then any PTO that the employee uses are going to have to comply with the requirements of these regulations. So that means if you have this general PTO policy that provides for 56 hours or more, and you say, well, it can be used for all the purposes, you also have to make sure that all the other obligations as far as the record keeping and responding to requests are complied with. The other option is you can maintain that PTO policy but track separately that when the employee uses the paid sick leave for the purposes enumerated under these regulations. And then in that case, if you track it separately, then you only have to comply with the requirements, the record-keeping obligations, as well as responding to the paid sick leave in the case of the paid sick leave law that you're tracking. So it's basically a subset of your PTO policy that you're tracking. That may be, from an administrative perspective, really the easiest to do, because if you don't do that and you don't track it separately, what you're going to be required to do is track all paid time off in accordance with the requirements of the regulations. So I think a lot of people will, I think a lot of contractors, I think the trend will be to moving away from the PTO policy and to track PTO separately from paid leave, or vacation and paid sick leave separately, just because it is less administratively burdensome, and I think it can be easier to administer from that perspective. All right, so we also have prohibitions under these regulations. They're pretty, obvious, quite frankly, but just so you know, you're prohibited against from interfering with any employee's rights under these regulations or their use of leave, and you can't retaliate against them for using their entitlements under the leave. So examples of interference that are cited is miscalculating the amount of paid sick leave that's accrued by an employee. If you deny or unreasonably delay in responding to an employee request, if you discourage an employee from using paid sick leave, or even reduce an employee's accrued paid sick leave more than the amount that's actually used. Those are all considered types of interference. You also cannot discharge or discriminate against an employee for reasons including using the paid sick leave, filing complaints under these rules, cooperating in an investigation by the Department of Labor under these rules, or informing others about their rights. So if you got an employee who's saying to a coworker, hey, you've got this paid sick leave, you're entitled to this, you're working on a covered contract, we can't take action against the employee for sharing that information with their coworker. Do know that an employee has no private cause of action, meaning the employee can't go into court and sue the contractor for failing to provide them with the entitlements to which they're entitled to under these regulations. What would happen is it's very similar to a violation of the Fair Labor Standards Act. The employee would file a complaint with the Department of Labor. The Department of Labor's Wage and Hour Division is charged with investigating and enforcing and administering these regulations, and they would go ahead and do an investigation. If the Department of Labor found that the violation had occurred, there's various remedies available under the regulations, and that would be pay or benefits that are lost or denied, actual monetary loss that's suffered as a result of the employee's failure to comply with the the employer's failure to comply with the regulations, liquidated damages, which is basically double the amount of back pay or other losses they may have. You can also be withheld payments on your contract, and the employee also may be, if you terminated them for using paid sick leave or along those lines, they also could be reinstated. Okay, so what do we recommend? So what do you need to do? So we've got the rule coming up. The effective date is Jan 1, 2017 to those covered contracts that we talked about. So what we want to do first is insert a clause that addresses requirements in your lower tier contracts. The full contract clause can be incorporated by reference in federal contracts and subcontracts with the language that essentially says executive order establishing paid sick leave for federal contractors and its implementing regulations, including the applicable contract clause, are incorporated by reference as it's fully set forth herein. That's all you need is just incorporating that language. There are also some helpful information on the DOL's website that can provide you with that language. You also have that flow down obligation with regard to your lower tier contractors and ensure that they're complying with these sick leave requirements. I would recommend probably following similar procedures that you do to ensure that your lower tier contractors are complying with their service contract obligations. You also want to make sure that, to the extent you're not doing so already, that employees' medical records and the records underneath that are going to be generated as a result of these regulations are kept separate and confidential. That's just best practices when we deal with any medical documentation. And you also want to go ahead and provide notice to your employees, who are going to be covered of these new paid sick leave requirements. There is a poster that you can find online. It's on the DOL's website. It's Workers' Rights under Executive Order 13760. And you're supposed to post that at a prominent place in the work site. You can also do an electronic posting as well that can satisfy this requirement. I also recommend that you incorporate this into your paid sick leave laws to the extent that this is going to apply to your employees. Okay, so this is where a lot of contractors really gave a lot of pushback when they commented on the notice of proposed rulemaking. It's these record-keeping obligations. They're really administratively burdensome. And unfortunately, the final rule really didn't see much of a modification to these record-keeping obligations. So again, these records need to be kept during the course of a covered contract and for 3 years after. I mean, 3 years is pretty standard as far as maintaining personnel documentation, but it's just know that this is required under the regulation. Now, some of these records you probably already maintain as a matter of course, and there's going to be other ones that I'm going to mention that you're going to say, oh my goodness, how am I going to keep track of all this? So the records have to be an employee's name, address, and social security number, their occupation or classification, the rate of wages paid, the number of daily and weekly hours worked, and remember what we talked about, those employees who are exempt under the Fair Labor Standards Act, that's not going to apply as long as you're giving them that 40-hour work week. You're assuming that they're working that 40-hour work week. You got to keep records of deduction from wages. You have to keep track of total wages paid during each pay period. Notifications of the employee's accrued amount of paid sick leave, as well as an employee's request to use paid sick leave. So if you got an employee asking in verbally requesting paid sick leave, we've got to document that. The dates and amounts of the paid sick leave used. And again, what I mentioned earlier, if you're going to deny an employee's request to use paid sick leave, you got to write it down. That is a record, so you've got to keep that during the course of the contract as well as at 3 years. Any other records related to the certification, so as we discussed earlier, any medical certifications that we were permitted to request and the employee provided. Any records showing tracking and calculations related to accrual or use, their regular pay and benefits for each use of paid sick leave, and any financial payment for accrued unused paid sick leave upon separation, and that only makes sense, quite frankly, as well as keeping covered contracts. Okay, so I'm going to switch gears here. That covers the main points of the mandatory paid sick leave for federal contractors, and we're going to save questions here for the end. And so I want to switch gears and talk about the Fair Labor Standards Act regulations. So I'm going to say at the outset, due to the results of the presidential election this week, although the regulations are scheduled to take effect December 1 of this year, there are injunctions in 2 states which are being argued next week that are trying to stop these regulations from going through. It is highly likely that a court is actually going to grant the injunction to give the new president the opportunity to either sustain or overturn the regulations. That being said, I still think it's important to talk about the regulations as well as your obligations under the Fair Labor Standards Act. So with regard to the new overtime regulations that are scheduled to become effective in a couple of weeks, the only thing that these new regulations have done is to change the salary threshold for employees to be exempt under the Fair Labor Standards Act. And when I say exempt, that means exempt from the minimum wage requirements as well as those overtime requirements. So employees who are exempt from the Fair Labor Standards Act means we don't have to pay them overtime, right? So there is a salary threshold that an employee has to meet to be exempt, as well as a duties test. I'm going to talk about the duties test in a minute, because the employee to be exempt has to meet both the salary threshold as well as the duties test. So these new regulations, the only thing that they're doing is changing the salary threshold. Currently, the salary threshold is $23,660,000 per year. So in order to be exempt, the employee's got to be paid on an annual salary basis that makes at least that much, right? And that's the current salary threshold. The new salary threshold is going to pretty much double that figure, and it's going to be $47,476,000 per year. It averages out to about $913 per week. So that's the only thing that's going to be changed with regard to that salary test. There's also, the new regs are also going to change the annual compensation to meet the highly compensated employee exemption. Currently, it's only $100,000. And so what that means is currently an employee to be exempt from the Fair Labor Standards Act, if they meet the salary threshold of $100,000 per year and meet one requirement of one element of a duties test, then they can be exempt from the Fair Labor Standards Act. The new regulation is going to just bump up that $100,000 figure to $134,004 per year. Again, this is just a salary change or a compensation amount. The new regulations also have an automatic increase. It's going to take place every 3 years. So the first one would be scheduled for January 2020. And basically, depending on different metrics, it's going to automatically increase. So what's going to happen is in 2020, under the new regs, it is going to be, the new salary threshold will be at least the 40th percentile of full-time salaried workers in the lowest earning region of the United States. So that's currently the Southeast. So in 2020, 2019, they'll go ahead and take a look, figure that out, and then that would automatically set to change, it would increase. And with regard to the highly exempt employee, it's the 90th percentile. And again, as I mentioned earlier, there is no change to the duties test. So I think it's a really great time, even if the new regulations don't go into effect and we don't have a new salary threshold to meet, it's a really great time, if you haven't already, to look and make sure your employees to be exempt are meeting one of the duties tests. And when I'm talking about one of the duties tests, it's the white collar exemption duties test. It's the administrative, the executive, and the professional, and for some of you there might be that computer professional exemption as well. And so you really want to take a look and make sure. I mean, in my experience, I have found that it's rare to have an employee who makes less than the salary threshold who also meets one of the duties tests. I mean, that's not to say that it can't happen, but typically the salary kind of can be reflective of whether they're going to meet the duties test. So with regard to those duties tests, I can go over them briefly. But with regard to the executive exemption, you have to be managing, the requirements are, you have to be managing a business or a recognized subdivision, and you have to be regularly supervising 2 or more full-time employees. So that means you're hiring and you're firing, you're doing the evaluations for them. So we can look at that one, and pretty much it's pretty clear right off the bat as to whether your employee is going to meet that executive exemption. The other is the professional exemption. The professional exemption, sometimes there is some confusion around this exemption because from time to time employers will think, well, my employee is working in an office setting, they're a professional. They come to work and they wear business attire and they're professional and thus they must be exempt. That's not the case. With regard to the professional exemption, you have to have, your primary duty has to be the use of advanced knowledge that has been acquired of a prolonged course of instruction. And that exemption is really reserved for doctors, it's reserved for your lawyers, it's reserved for your accountants. So again, that is usually a fairly easy call as to whether your employee is going to meet that professional exemption. The other exemption I just want to touch base on is the administrative exemption. This is the one that I think I spend probably the most time talking to my clients about. This is kind of a catch-all because if the employee doesn't fit into any other category, we talk about the administrative exemption. And again, the administrative exemption is going to require as the primary duty discretion and independent judgment over matters of significance. And where some of the confusion regarding this particular requirement for the administrative exemption comes in is this discretion and independent judgment. Unfortunately, the Department of Labor does not view discretion and independent judgment in quite the same way that you and I may. So if an employee is following pre-established procedures and they have guidelines that they're following, that typically is not, in the eyes of the Department of Labor, is not going to be work that requires discretion and independent judgment. So, for example, an HR generalist. An HR generalist, even if they meet the salary threshold of $23,660, or even if they meet the new salary threshold, if their primary duty is I'm sending out offer letters, I'm filling out paperwork, I'm administering changes in payroll and things like that, that is not typically is not going to be work that is going to be exempt and includes discretion and independent judgment. And again, in order to be exempt, that employee needs to meet both the salary threshold as well as one of the duties tests. So that is my quick summary of the Fair Labor Standards Act. The new regulations are going into effect. Again, there's a whole lot that I can talk a lot more about that, but I'm going to end it now and then turn it over for questions. Okay, I have a question here, and I touched on it a little bit. What, if any, changes do you believe that the Trump administration will make to the paid sick leave rule or the enforcement? With regard to the paid sick leave rule, I don't know if there's going to be anything that will be changed. There's not the challenge that there is to the Fair Pay and Safe Place Workplaces Act. We already have an injunction with regard to those regulations. I don't know if there are going to be any changes with regard to this or to the rule enforcement. My guess would be if there would be any changes, it would be a complete overruling of the regulations rather than a parsing out and only changing certain aspects of the regulations. My guess is it would be a full, override of the regulations. However, as it stands now, it's going to be these regulations are going to be going into effect Jan 1. All right, I don't think there are any other questions. So, Brent, I'm going to turn it back over to you.
Thank you, Jennifer, and thank you for the enlightening presentation. We'll have our next NVTC committee meeting December 8th. It's going to be a happy hour from 5:30 to 7:30, hosted by Salient. We are still looking for a food and beverage sponsor for that event, so please reach out to me or NVTC if you're interested. In addition, all participants today can take advantage of a free 90-minute paid sick leave checkup provided by Xerox, and I will email the flyer and the details of that offer to all the participants in the call today. Thank you again for your time, and have a great day.